The most recent exercise of unfortunate decision-making in the voting rights area came just hours ago when the Supreme Court struck down the decision of the Wisconsin State Supreme Court in Wisconsin Legislature versus Wisconsin Elections Commission. What is striking is not only the result, but the fact that it was done as part of the shadow docket. We've talked a lot about it here, and what the people of America should know is there's no oral argument, there's only minimal briefing, there are no full opinions of the court. In fact, I'm holding up a per curiam opinion that is about 12 pages in length from the court, which means you don't know who wrote it, and there is a powerful dissent. I recommend that everyone read it. Again, use of the shadow docket has become increasingly prevalent since 2017, and in effect, the United States Supreme Court is shirking its duty. I hope you will bring to the court the kind of responsible and methodical approach to decision-making that will lead to an avoidance of the shadow docket, as well as a return to the Voting Rights Act. And if I can just offer one more piece of advice on the court's workload, I have a chart. I know we're not going by the rules of evidence here, but this chart indicates the signed decisions of the United States Supreme Court over a good part of its history. And I think the pattern here is pretty clear. The court issues fewer signed opinions. In fact, it has declined precipitously since 1972. This little blip at the end here is an increase from 53 to 57, but you can see it's only a fraction of what the court used to do in signed opinions. Even from the time when I was a law clerk, it's diminished profoundly. The Supreme Court needs to do its job. It needs to issue signed opinions, not the shadow docket. It needs to take cases and resolve real, fundamental, important issues. And taking your record, 573 opinions over 9 years. I'm not a math major, but that's about 64 opinions a year. That's a lot more than they do, all 9 of them. So I hope you will bring the energy that you have demonstrated in this room, the energy and the work ethic to the United States Supreme Court, because clearly you have both, and I think the court is very much in need of it, as it is some of the other great qualities, intellect, character, that you have demonstrated here.